Letter of credits, though create comfort zones for all the parties involved, it has a tougher pass-through and all the parties need to exercise their due diligence according the terms and conditions of the letter of credits, the applicable provisions of UCP 600 and the International Standard Banking Practice. Welcome back to the complex trade finance topics that we shall try to make simple and easy to understandable. Let us getting into the deep of one of the most critical articles in the UCP 600, that is Article 16, titled as Discrepant Documents, Waiver and Notice. Trust me, if you are in international trade cycle, you need to know this article inside and out. It can be the difference between a smooth transaction and a major headache, so take a notebook and let us get started. First of all, what exactly is Article 16 all about? In simple terms, it lays out the rules for what a bank must do when it receives documents under a letter of credit, or LC, and finds discrepancies. A discrepancy is any failure to comply with the terms of the LC. It could be a typo, a missing signature, a late shipment, anything that doesn't match the LC's requirements perfectly. Sub-Article 16 says, when a nominated bank acting on its nomination, a confirming bank, if any, or the issuing bank determines that a presentation does not comply, it may refuse to honor or negotiate. That means it has a choice. For an example, an issuing bank in United States has received a presentation from an exporter of ready-made garments in Vietnam. It has started its action under its undertakings. The issuing bank scrutinized the presentation, found a single valid discrepancy with 5 banking days. It may refuse the documents now by a single notice as detailed in Sub-Article 16c Roman 1 or 2. Now the Sub-Article 16b comes in action. According to this sub-article, when an issuing bank determines that a presentation does not comply, it may in its sole judgment approach the applicant for a waiver of the discrepancies. This does not mean, however, extend the period mentioned in sub-article 14b. The bank now has further option in addition to directly refusing the documents. The bank may approach to the applicant for waiver of the discrepancy, but such notice must be communicated and must be concluded according 5 banking day rules of sub-article 14b of UCP 600. For example, if documents are presented on a Monday, the bank has until the close of business on the following Monday to act, assuming no weekends or holidays interfere. What if the traced discrepancy violates legal binding of the importing country or the compliant practices of international standard? Yes, therefore, the sole judgment of the issuing bank will be applied. The issuing bank must not breach the greater interest of the legal bindings and global standard regulations for such waivers. Now sub-article 16c is for strict procedures for this refusal. When a nominated bank acting on its nomination, a confirming bank, if any, or the issuing bank decides to refuse to honor or negotiate, it must give a single notice to that effect to the presenter. First, it must state that the bank is refusing to honor or negotiate, sub-article 16c Roman 1. A simple statement like the bank refuses is enough. But sub-article 16c Roman 2 says that banks must list each and every discrepancy that led to the refusal. When a bank finds single discrepancy, it will mention it specifically. When the bank finds multiple discrepancies, it must mention all in serial and with specific references without fail. The bank cannot just say documents are discrepant. It has to spell them out. For example, bill of lading not signed as per UCP 600, Article 20, or commercial invoice value exceeds the LC amount. If a bank fails to list a discrepancy in its initial refusal notice, it cannot bring it up later. This is a one-shot deal. Let us imagine another scenario. a Vietnamese exporter of ready-made garments, who is also the beneficiary of the LC, ships goods to a buyer in Germany. They present the documents to their bank, which forwards them to the issuing bank in Germany. The issuing bank reviews the documents and finds two discrepancies. The certificate of origin is not signed, and the bill of lading shows a transshipment that was explicitly prohibited in the LC. The issuing bank must send a notice to the presenting bank by the 5th banking day. This notice must clearly state, "We refuse to honor due to the following discrepancies." 1. Certificate of origin is not signed. 2. Transshipment occurred, which is prohibited by the LC. Now, after listing the discrepancies, the notice must also state what the bank is doing with the documents. Article 16C outlines for possible actions. 1. The bank is holding the documents pending further instructions from the presenter. This is a common option. 2. The bank is holding the documents until it receives a waiver from the applicant and agrees to accept it. 3. The bank is returning the documents to the presenter. Or 4. The bank is acting in accordance with instructions previously received from the presenter. The notice must specify which one or more actions are taken. So, a complete refusal notice might end with mentioning the specific discrepancies and saying we are holding the documents at your disposal pending your instructions or any of the 4 options mentioned. What happens if the bank messes up this process? Yes, sub-article 16D expresses, the notice required is sub-article 16C must be given by telecommunication or, if that is not possible, by other expeditious means no later than the close of the 5th banking day following the day of presentation. Also, the sub-article 16E says, a nominated bank acting on its nomination, a confirming bank, if any, or the issuing bank may, after providing notice required by sub-article 16C3A or B, return to the presenter at any time. Let's say the bank takes 6 banking days to send the refusal notice, or it sends the notice on time but forgets to list one of the discrepancies. According to sub-article 16F, if an issuing bank or a confirming bank fails to act in accordance with the provisions of this article, it shall be precluded from claiming that the documents do not constitute a complying presentation. It means the bank must honor the presentation and pay the beneficiary, even if the documents are full of errors. The rules are strict for a reason. They ensure fairness and certainty for the beneficiary. The beneficiary needs to know quickly and precisely why their documents were rejected so that they can take corrective action if possible. Now let's talk about the waiver. This is covered in sub-article 16B. Even with discrepancies, the issuing bank has the option to contact the applicant, the buyer, and ask if they are willing to waive the discrepancies. The applicant might say yes, especially if they desperately need the goods. For instance, if the only discrepancy is a typo in the goods description, the buyer will likely waive it. However, the bank is not obligated to seek a waiver. It can refuse outright without ever contacting the applicant. If the applicant agrees to waive the discrepancies, the issuing bank can then choose to accept the waiver and honor the presentation. Notice the word choose. The bank is not bound by the applicant's waiver. Why? Perhaps the bank has concerns about the applicant's ability to reimburse them or the strict regulations. The ultimate decision to pay rests with the bank based on its own risk assessment. Let's consider a more complex case. An LC requires a full set of 3 out of 3 original bills of lading. The beneficiary only presents 2 out of 3 originals. This is a major discrepancy. The issuing bank sends a timely and proper refusal notice. The beneficiary, panicking, asks the bank to contact the applicant for a waiver. The applicant, who needs the goods for a seasonal sale, agrees to waive the discrepancy. The issuing bank, however, has just heard that the applicant is facing financial trouble. Fearing they would not be reimbursed, the bank decides not to accept the waiver and maintains its refusal. Or, the bank receives a presentation against shipment of radioactive goods. The level of radiation required by the LC crossed as per radiation certificate presented. Here is the legal and regulatory issue, and the bank will use its sole judgment. This is perfectly within the bank's rights under UCP 600. Another layer of complexity is when a nominated bank is involved. Let us say a nominated bank in the seller's country has negotiated the documents, meaning they paid the seller believing the documents were compliant. They send the documents to the issuing bank. The issuing bank finds a discrepancy that the nominated bank missed. The issuing bank refuses and sends the Article 16 notice back to the nominated bank. Now the nominated bank has a problem. They have already paid the beneficiary, but the issuing bank is refusing to reimburse them. The nominated bank now has recourse against the beneficiary to get their money back. The nominated bank must ensure that such kind of negotiation happened with recourse and before presentation of full set of documents to its counter. What is with recourse? It means that the bank has taken guarantee or the full coverage of security against the negotiation or the purchase. What if that nominated bank missed the valid discrepancy that the issuing bank or the confirming bank sorted out, and it has negotiated or purchased the documents without recourse? The nominated bank is then in real danger of non-reimbursement scenario. Sub-Article 16G reflects when an issuing bank refuses to honor or a confirming bank refused to honor or negotiate and has given notice to the effect in accordance with this article. It shall then be entitled to claim a refund with interest of any reimbursement made. This shows why all banks in the chain need to be experts at document checking with ample knowledge on all the related rules and international standard practices. To wrap things up, Article 16 is the rule book for handling things when they go wrong. It protects the beneficiary by ensuring any refusal is timely, complete, and clear. It gives banks a structured process to follow, minimizing disputes. And it provides a mechanism, the waiver, that can save a deal despite minor errors. But it also holds banks to a very high standard. A failure to follow the procedure of Article 16 precisely can force a bank to pay against non-compliant documents. That's why, for anyone working with letters of credit, mastering this article isn't just a good idea, it's essential for survival. Thank you so much for tuning in today. Though a long stressed article has been gone through, I am sure it certainly benefited you. If you found value in this video, please hit that like button, subscribe to our channel, and ring the bell so you don't miss our next deep dive into trade finance. If you have any questions or a complex scenario you want to discuss, please drop it in the comments below. I love hearing from you. Until next time, trade safely and practice well in the International Trade Service divisions compliantly. Thanks again.